Today on Bench Briefs, we're looking at a significant case involving environmental law, Indigenous rights, and the government's duty to consult. Sierra Club Canada Foundation versus Canada is a 2026 decision from the Federal Court of Appeal that explores how the Crown must engage with Indigenous communities before approving projects that could impact the environment. So, what's this all about? The Sierra Club Canada Foundation, a well known environmental organization, challenged a federal government decision under the Impact Assessment Act. This act is designed to ensure that major projects are carefully reviewed for their environmental impacts before they get the green light. But the Sierra Club argued that the government didn't do enough when it came to consulting Indigenous groups who might be affected by the project. Here's the background. The government approved a proposed development project, but Indigenous communities raised concerns about the possible environmental consequences. Under Canadian law, the Crown has a constitutional duty to consult and sometimes accommodate Indigenous peoples when actions might affect their rights or interests. This duty stems from Section 35 of the Constitution Act, 1982, which recognizes and affirms Indigenous rights. It's a crucial protection aimed at fostering respect and reconciliation. The Sierra Club's challenge focused on whether the government had met that duty properly. They said the Crown's consultation process was inadequate, that Indigenous voices weren't fully heard or considered before the project was approved. This wasn't just about procedural steps. It was about whether the consultation was meaningful and substantive, ensuring Indigenous concerns were genuinely addressed. The legal questions before the Federal Court of Appeal were threefold. First, did the Crown fulfill its duty to consult Indigenous groups according to constitutional and statutory requirements? This meant looking closely at what the government did, how it engaged with Indigenous communities, and whether that engagement was sufficient given the potential impacts. Second, the court had to determine the appropriate standard of review. In other words, how strictly should the court scrutinize the government's consultation process? Should the court show deference to the government's administrative decisions, or should it take a more hands-on approach to ensure fairness and legality? Third, the court examined whether the administrative decision to approve the project complied with principles of administrative law, including procedural fairness. This means checking if the government followed the right processes, gave proper notice, and allowed affected parties a fair chance to participate. The Federal Court of Appeal's decision clarified important points about the duty to consult in the context of environmental approvals. It emphasized that consultation must be meaningful and tailored to the specific circumstances, including the nature of the project and the potential impacts on Indigenous rights. Simply going through the motions isn't enough. The court also confirmed that while some deference is owed to administrative decisions, courts have a vital role in ensuring that the Crown's consultation obligations are met in a way that respects constitutional protections. This helps strike a balance between respecting government expertise and safeguarding Indigenous rights. Why does this case matter? It highlights the ongoing importance of Indigenous consultation in environmental governance, a topic that's increasingly relevant as Canada pushes forward with resource development and climate change initiatives. The ruling reinforces that environmental protection and Indigenous reconciliation must go hand in hand, and that government decisions can't sidestep meaningful engagement with Indigenous peoples. For environmental groups, Indigenous communities, lawyers, and policymakers alike, this case serves as a reminder that the duty to consult is a living, evolving principle. It requires careful, respectful dialogue and genuine efforts to address concerns before approving projects that affect the land and its people. Thanks for listening to this episode of Bench Briefs. Be sure to join us next time for another deep dive into a compelling Canadian legal case. Until then, take care.